Well, a lot of it has to do with what kind of adversary proceeding we're dealing with. Perhaps the most common type of adversary proceeding is an exception to discharge adversary. So what do I mean by that? Well, in an individual case, there are three kinds of debts that are not dischargeable. Well, maybe I should take a step back. They are dischargeable unless the creditor successfully challenges their discharge. Their debts incurred through fraud, debts that are the result of a breach of a fiduciary duty, and debts that are the result of doing willful and malicious harm to a person. Now, if it's not a Chapter 13, that third one also includes willful and malicious harm to property. So a lot of it's going to depend on what the creditor presents as its argument. So, for example, if it's fraud, the creditor has to prove fraud. So there are technical things that come up in establishing what fraud is. One of them, for example, is something called detrimental reliance. So if the claim is that the debtor made a false statement and the idea was that it was supposed to induce the creditor to lend money or extend credit, and the creditor wouldn't have done so but for that lie, there has to be something in the evidence that establishes that the creditor relied on the misrepresentation of the debtor when the debtor incurred the debt. So if the creditor can't establish detrimental reliance, then the debtor wins the adversary proceeding. Generally speaking, each type of adversary will have causes of action in the complaint. And those causes of action have elements that have to be established, such as with fraud, there has to be detrimental reliance. So you can almost think of it as a checkbox. Did you prove this? Did you prove this? Did you prove this? And with each body of evidence that the creditor presents, the debtor is going to have to confute that body of evidence with the debtor's own evidence, perhaps in the form of documents, in the form of testimony, and maybe even in the form of expert witness testimony. So it's hard to make a blanket statement of what does the debtor have to do to defend in an adversary proceeding. Sometimes a debtor is the one that initiates the adversary proceeding, and then the debtor isn't the defendant, but rather the plaintiff. That's a different kettle of fish, as it were. But your question asked, how does the debtor defend in an adversary? So I suppose the best summary answer is take a look at the cause of action, or sometimes there's more than one cause of action listed in the complaint. List the elements that are associated with that particular cause of action. Take a look at what the creditor is alleging, and then see if you have evidence to successfully dispute each one of those elements that the creditor is asserting. And if you can do that, then you will succeed.